Hello, everyone, and welcome to the 2025 Hot Topics in Environmental Law Summer Lecture Series. Christophe Courchain, Faculty Director of the Environmental Law Center and Associate Dean for Environmental and Experiential Programs here at Vermont Law and Graduate School. Each talk in our Hot Topics series is worth 1 Vermont CLE credit, so please keep track of which talks you attend for your records. We will have time for Q&A after today's presentation, so for those of you who are watching live on the VLGS YouTube page, you can enter your questions at any time on the right-hand side of the page in the chat box, and we'll get through as many questions and comments as we can. Today, we are pleased to welcome Madison Condon. Professor Condon joined Boston University School of Law as an associate professor in July 2020. She teaches environmental law, corporations, and a seminar on climate risk in financial institutions. Professor Condon is an expert on climate change, financial risk, and regulation. Her scholarship has been included in collections of the best articles of the year for several fields, including environmental law, corporate law, and securities law. Her research has been relied upon by the U.S. Securities and Exchange Commission and the U.S. Department of Labor in their rulemakings. President's Council of Advisors on Science and Technology pointed to her work criticizing financial models and its recommendations for managing extreme weather risk. In 2023, Professor Condon joined the United Nations Principles of Responsible Investment Academic Network Advisory Committee. Professor Condon's scholarship has appeared in leading legal journals, interdisciplinary publications, and been featured in popular media outlets, including the New York Times, Bloomberg, NPR, Politico, The Atlantic, and The New Republic. Before joining BU, Professor Condon was an attorney at New York University School of Law's Institute for Policy Integrity, where she participated in litigation against federal regulatory rollbacks. She clerked for Judge Jane Kelly of the Eighth Circuit Court of Appeals and was a postdoctoral fellow with the Earth Institute at Columbia University. Professor Condon holds a JD from Harvard Law School, an MALD from Tufts University's Fletcher School, and a BS in Earth and Environmental Engineering from Columbia University. She was a Fulbright Fellow to the Netherlands, where she researched water resources management. Professor Condon joins us this summer at VLGS as our 2025 Distinguished Climate Law Summer Scholar. Today, she'll present universal ownership, systematic stewardship, whatever you call it, where do we stand? Please join me in welcoming Professor Madison Condon.
Thank you so much, Christophe. I've been having a truly lovely time here at Vermont Law. It's been okay, I think we're back. I'm really sorry about that. My computer just crashed as I went to share my screen. Hopefully, it will let me do it this time. Here we go. Okay, hopefully we're working. Okay, do we have it? You can see my screen?
Absolutely.
Hopefully no more snafus going forward. Okay, sorry about that. All right, so here is my talk, universal ownership, systematic stewardship, whatever you call it, where do we stand? And I submitted this talk title and I realized that it's a bad title, honestly, because if you don't know what these terms mean, then you don't really know what I'm about to talk about. So a better title would have been Legal Challenges to Investor Climate Action, More specifically, I'm going to focus my talk about the specific legal challenge to investor climate action of recently filed antitrust litigation, and some of the broader implications for the intersection of competition law and climate policy, private climate policy. So as a subtitle with an academic journal title flourish might be Competition and Collaboration in the Decarbonizing Economy. Okay, so back to my original title, what is universal ownership or systematic stewardship? Universal ownership is basically a theory that has been around for a few decades, but really exploded in importance in the context of climate change. And the argument is that large institutional investors, which include asset owners like pension funds and sovereign wealth funds, as well as asset managers like BlackRock and Vanguard, they are broadly diversified across the economy, such that economy-wide impacts, economy-wide harms, like climate change, hurt long-term portfolio returns. And so the argument is that it would be economically rational for asset owners, like state pension funds, to work towards decarbonization, to essentially pressure the fossil fuel companies within their portfolio to decarbonize, pressure the automobile manufacturers within their portfolios to decarbonize for the benefit of all the other investments in their portfolio, including agricultural companies and real estate conglomerates, for example. Another way of putting this is to use sort of financial terminology and financial risk terminology and use a systematic framing, which makes a similar argument, but in terms of undiversifiable risk, which I won't get into the details. But for our purposes, what you need to know is that this theory has been really growing in influence. There's been a ton of academic papers about universal ownership. A lot of climate nonprofits have been advocating for investors to behave like universal owners. And very importantly for our purposes, a growing number of investor alliances, maybe a diminishing number in more recent times, but there's a big flurry of activity around 2020, 2022, where a bunch of investor climate alliances have adopted this basically economic argument that it would be better for long-term portfolio returns if investors work towards decarbonization. So I first wrote about this back in 2020. I argued basically what we talked about in the previous slide, that institutional owners would satisfy a cost-benefit analysis if they worked towards decarbonization, even if this meant forcing individual firms to sacrifice profits. So I basically did a pretty crude cost-benefit analysis, arguing that the mitigated damages in 2040 and 2050 to portfolio harms outweigh even sacrifice profits today from fossil fuel companies. I raised potential legal dilemmas, including antitrust and fiduciary duties of both corporate boards and investment fund managers. And since I wrote about this back in 2020, whether investors can and should do this has become a matter of great legal debate, including from anti-ESG Republicans. So when I first wrote this article, I was an unknown fellow. I was hoping that anybody would read this article. I thought it was sort of a fun idea I had. Little did I know that 4 years later, the House Judiciary Committee would cite this article in support of their argument that institutional investors are anti-competitively colluding through ESG to harm consumers in the energy markets. So sort of weaponized in a way that I did not see coming. So just to back up and to set the stage a little bit, so maybe even starting before 2019, maybe 2017, 2019 really picked up speed and broke a lot of headlines. Through 2023, we have the rise and proliferation of ESG initiatives. So investors, private investors, and also public investors like pension funds, really caring about climate change targets for their own climate change targets and also climate change targets for the companies that they themselves invest. And a bunch of institutional investors joined these industry coalitions that were formed. Climate Action 100 Plus pledged to pressure the 100 biggest emitters of publicly traded emitters, try to pressure the 100 biggest companies in their portfolios. Net Zero Asset Managers Initiative similarly pledged to work towards decarbonizing the companies that they invest in. And of course, a bunch of banks and financial institutions themselves made a bunch of their own net zero pledges. And then we had the anti-ESG backlash. And in response to this backlash, many US asset managers then exited these climate alliances that they had only been members of for a couple years. And this backlash consisted of red state legislation banning states from doing business with financial institutions that had climate targets. So BlackRock and State Street, for example, were put on blacklists in Texas and in West Virginia. And the backlash also consisted as many letters from states' attorney generals alluding to potential fiduciary duty and antitrust violations were sent to many of the fund managers that had stated climate goals. So I would say most US financial institutions at this point that are private have exited these climate alliances. A lot of the blue state pension funds remain in. And importantly, actually, abroad, the interest in climate targets and interest in this universal owner framing remains robust. So this is on the right side of the slide, you have one of the largest public pension schemes in the UK. And this is still up on their website. I just screenshotted it yesterday. USS still claims to be a universal owner. They say they still are interested in the growth of the entire economy. They're still interested in diminishing externalities that are harmful to their portfolio. So in the UK and the EU, this has not been an issue. And in fact, investor coalitions are moving full speed ahead on thinking about how they can behave like systematic stewards. Okay, so zooming out just a little bit more before we return to a specific instance of the legal assault against investor climate action. Here are some of the leading theoretical challenges to universal owner theory. So here I've grouped them into 4 buckets. There's been a lot of arguments from all across the political spectrum, actually arguing that universal ownership is a bad theory or a wrong theory, should not be operationalized, cannot be operationalized. So here's my 4 groupings. The first is an economic argument that is basically a cost-benefit analysis argument, saying that the economics of emissions reduction don't work out. It's not actually worth it for investors to sacrifice present-day fossil fuel profits for the benefit of diminished long-term harms to their portfolio. This argument mostly rests on assumptions that climate change won't hurt companies in the global north. It sort of disregards both impacts that we know will happen in the global north and honestly it disregards a lot of sort of globalization and supply chain impacts. The next bucket of critiques against the universal owner framing is that it's simply not possible for investors to influence the global decarbonization pathway. In one sense, critics mean that it's not possible for investors to use their influence through corporate governance mechanisms to influence investment decisions like product supply and pricing. They're saying what institutional investors do is they operate in a very high level. They can vote for or against directors. They can vote for or against shareholder proposals, but they're not actually able to, like puppeteers, affect the output and pricing decisions that are made on a day-to-day basis by corporate managers. A related argument to both the economic argument and the plausibility argument is that any action taken by any individual firm would be drowned out by competitive effects, or what we in the environmental world would call leakage effects. But the idea is that investors can only influence companies within their portfolio. They can't influence companies that are beyond their portfolio, like Saudi Aramco or other state-owned enterprises beyond BlackRock's influence. So any pressure that BlackRock exerts on Exxon is going to be equally made up for by any of these state-owned enterprises like Aramco. A third critique of the universal owner framing is that it's illegal for investors to behave like universal owners, and or it's illegal for corporate boards to do what their universal owner investors would want them to do. It is either an anti-competitive violation or it violates their fiduciary duties. And finally, the last critique of universal owner advocacy or framing is that there is an agency cost or a transaction cost in between asset owners like pension funds and the asset managers that they hire to manage their money. So the argument is basically, even though it might be in CalPER's best long-term interests or the beneficiaries of CalPER's best long-term interests to work to decarbonize their portfolio, they have a very hard time sort of making the asset managers that they hire carry out their intent. CalPERS has a very hard time making BlackRock work towards decarbonization goals. So these are the four main arguments against universal ownership. I'm mentioning now because they're going to come up in their own ways throughout the rest of the discussion, and I'm happy especially to talk about these in the Q&A because I've thought about a lot about each of these arguments. But for the purposes of this talk, I really want to focus on this third argument, on whether it's illegal for corporate boards and investors to behave like universal owners. Is it perhaps an antitrust violation? So that's what I'm going to talk about for the basically the remaining portion of this talk. And I'm going to explore this theoretical question, through one timely case in particular. So in late 2024, so the end of last year, a coalition of red state attorneys general led by Texas filed an antitrust lawsuit against some of the three largest asset managers, BlackRock, Vanguard, and State Street, alleging that their climate coalitions, their climate pledges, had resulted in anti-competitive restrictions in the coal industry, in particular in coal output in the South Powder River Basin. So it was filed at the end of last year. Just in May of this year, Trump's FTC and DOJ filed their own brief in support of the plaintiff AGs, saying that, yes, BlackRock did in fact behave collusively to restrict coal output. So let's dive in to the details of this case a little bit. Texas versus BlackRock. The claim focuses on three publicly traded coal companies operating 6 of the 12 total coal mines operating in the Southern Powder River Basin. And it alleges that in response to a 2022 Southern Powder River Coal Basin price spike, mines did not increase output as much as they would have in a competitive market. So one difficulty for the claim, frankly, for the red state AGs, is that output does actually increase over this period. So they're having to argue a pretty difficult claim, from my assessment, is that the argument is basically that had they been operating perfectly competitively, they would have increased output more than they did in fact increase output in response to this price spike. So that's the claim. And here on the right side of the slide, you can see the holdings, the shareholdings of BlackRock, Vanguard, State Street in each of these large coal companies. And I want to point out, these are actually pretty huge numbers. So BlackRock owns 13 to roughly 16% of the three coal companies. Vanguard owns 11 to 13%. State Street is a little bit smaller. But you can see these three institutional investors control roughly a third of these coal companies. One thing I just want to say about that is that these are due to the investors' size. It's not necessarily due to their unique interest in coal. So this is the thing to understand about BlackRock, Vanguard, and State Street. They own similarly sized stakes, or maybe slightly smaller in the case of BlackRock, for most large publicly traded companies. So BlackRock owns 5 or upwards of 5% of, look it up, basically most of the S&P 500. And so this is just a result of the ways that BlackRock, Vanguard, State Street invest. They mostly follow an indexing approach. They just try to buy a slice of the entire market, slice of the entire S&P 500, and they're enormous. So it's not that they love coal, it's just that they own a lot of all companies. All public companies. Okay, so what does the complaint allege? The Attorney General's complaint focuses in particular on membership in these climate alliances that I mentioned earlier. And this is what the complaint says. I need to move my little thing. From the AG's complaint. Signatories to Climate Action 100+ commit to influencing corporate policies and ensuring that firms take action to reduce greenhouse gas emissions across the value chain, in line with the overarching goals of the Paris Agreement. They established alignment metrics that set specific target reductions for coal production, including medium-term and long-term targets. And the complaint also alleges that signatories to the Net Zero Asset Managers Initiative specifically commit to phasing out coal investments. This includes ceasing all financial and other support to coal companies that are building new coal infrastructure. Okay, so just a note as we keep running through the complaint in this case, they each signed each of the three, so not all of the three investor defendants signed all three of these pledges, and we'll get into which one signed what. But of course, importantly, signing an aspirational pledge, you could have done that for many reasons, including marketing reasons. It could have been greenwashing. It is not the same thing as carrying out the pledge. So just saying that you are going to try to work towards the elimination of coal does not mean that you actually tried to do that in any way. So for example, HSBC Bank agreed to align its financing activities with the Paris Agreement, including financing coal-fired power and thermal coal mining. And yet it has pretty consistently, this is the second year running, broken its pledge to phase out coal and has continued to finance coal. So of course, signing a pledge and doing what the pledge says is not the same thing. So what did each of the named defendants actually do in this case? And I think most importantly for the purpose of this case, they did not all do the same thing. So BlackRock and State Street both joined Climate Action 100+, Vanguard did not. All three of them did join the Net Zero Asset Managers Coalition, although Vanguard joined it for less than 2 years. Both BlackRock and State Street did vote against board of directors, specifically for climate reasons. So I think this is pretty interesting. BlackRock, over the course of a few years, did vote against hundreds of directors with the stated purpose that they didn't think that their company was managing the transition correctly. They either weren't disclosing emissions targets enough, they hadn't set targets, or they just weren't, their business was not properly poised. They weren't making the right capital expenditure decisions today in order to survive the transition in BlackRock's estimation. So BlackRock did vote against directors for this reason. But neither BlackRock nor Vanguard actually met with the boards of companies. The only, I messed this up. Only Vanguard met with these companies. BlackRock and State Street actually did not. So this slide is actually wrong. Only Vanguard was the one meeting with the companies. BlackRock and State Street did not. Now, all three have withdrawn from the investor coalitions and have mostly ceased to support climate shareholder resolutions, basically as a result of this anti-ESG backlash. So there are two main claims that the attorney generals are making about how this activity resulted in an antitrust violation. The first claim is that it violates the Section 1 of the Sherman Act, which is a conspiracy and restraint of trade. In order to win on this claim, the AGs have to prove that there was an actual agreement between the defendant parties. Parallel conduct alone is not enough. There must be some additional plus factor, such as evidence that the defendants took actions that would have been against their self-interest if acting independently, but consistent with their self-interest if they were acting in concert. So here I'll just note, I think this is where one oddity of this case starts to become clear. So the plaintiffs are alleging unfair output decisions in the coal market, but they are not suing coal companies, the ones that actually operate in that market, because politically they like coal companies. But it's hard to see how institutional investors could have orchestrated such a conspiracy in the coal market without the complicity of coal management, which the AGs don't actually want to name as defendants. So the agreement has to be found. In order to be found guilty here, the agreement has to be found between BlackRock, Vanguard, and State Street, of which there's really no evidence that these institutions ever met or talked to one another about climate ever. They're not talking about agreements in between the coal companies. The second claim is that it violates Section 7 of the Clayton Act, which prohibits buying stock when the effect of the purchase would be to substantially lessen competition. There is a safe harbor defense in this part of the Clayton Act for stock that is bought solely for investment and not used to lessen competition. And the defendant's main defense here is that the plaintiffs don't really show how they used their stock, how they voted their stock, or otherwise used their stock to lessen competition. There's no causal connection between what the investors did and the output decisions of the coal companies. So basically they're saying, yes, we did sometimes vote against directors saying they weren't prepared to manage climate change, but even in those votes, we lost those votes. The directors were reelected anyway, even against our oppositional vote. So how can you connect that losing vote we made with output decisions about how much coal to produce? So this is BlackRock et al. So all three of their defense theories is basically, we acted alone. We didn't agree to act together. And every time we did something that was related to climate change, and every time we used corporate governance pressure on these companies related to climate change, it was for that company in particular. We were legitimately worried about a firm-specific risk. We were legitimately worried about stranded assets. It was not about controlling intra-firm externalities. It wasn't about universal ownership. It was simply that we were worried that this coal company was going to go bankrupt. And so we were trying to limit their expansion. We want to make sure the companies are not wasting the capex on projects that won't be paid when demand inevitably craters. So BlackRock is saying, we think the transition is happening. We think that coal demand is going to go down. Of course, we're trying to make sure that returns are going back to shareholders rather than being poured back into coal expansion. Okay. So I think that Texas versus BlackRock poses a hard set of questions. Can BlackRock or can investors practically work towards decarbonization? If BlackRock, Vanguard, and State Street's defense is that they don't have the power to influence market-wide coal output decisions, then why do climate advocates spend so much energy protesting them? Why is there so much nonprofit money poured into shareholder advocacy as a means for emissions reduction if BlackRock, Vanguard, and State Street actually don't have the ability to reduce market-wide fossil output? If they can influence market-wide product supply and pricing decisions, is this or should this be illegal? Does the current legal regime allow for differentiation between good coordination and bad coordination? So I'm just going to put those questions out there and offer a few thoughts on the topic before I conclude. So some comments on this case in particular. It seems hard for the Attorney General's case to move forward without alleging a causal mechanism between what the defendant investors did and the output decisions made by the coal companies. And I think in my reading of the complaint, they really don't provide any plausible evidentiary connection between these two decisions. I do think, however, that it is possible, even though it doesn't seem like that they have written a winning complaint, I think it's possible that this case could transform into something that becomes an inquiry into whether BlackRock's financial assessment about the inevitability of coal decline, whether that in fact is a political stance. So take something that we would have normally considered to be sort of an apolitical financial decision about how the markets will move in the future, and whether that becomes taken, that act of forecasting and assessment itself becomes taken as a political stance. So let me say a little bit more about what I mean. We have seen the willingness of federal courts to entertain pretty outlandish anti-ESG claims. Earlier this year, a federal judge in Texas issued a very surprising ruling holding that American Airlines had violated its fiduciary duties to its employees by putting their retirement fund in the management hands of BlackRock. And the judge reasoned that even though the employees' retirement funds were just normal funds, they were not ESG funds, they were just regular investment funds, S&P 500 funds managed by BlackRock. The judge reasoned that because BlackRock followed an ESG voting policy across all of its funds, and because BlackRock was so outspoken on climate change and talked about decarbonization all the time and had joined all the investor agreements, the judge ruled that it was a violation of fiduciary duty to even let BlackRock manage those non-ESG labeled funds. So that was a very surprising ruling. And I want to note that this behavior of BlackRock that the judge in this case earlier this year found objectionable. And so the behavior that the judge found objectionable is that BlackRock voted the same way, whether or not your shares were held in an ESG fund or they were held in a normal S&P 500 fund. It would vote the shares the same way. And the judge found that very objectionable. I want to note that this behavior by BlackRock is actually very consistent with its defense, that it was simply considering firm-specific business risk in the face of declining demand. It was just making an apolitical financial decision for the basis of that coal company in particular. It had nothing to do with overall emission goals. It just felt like the transition was happening and they were trying to manage risk. So I'm going to say a little bit more about what I mean about emissions forecasts becoming political or being political sort of fundamentally. One thing I mean is that finance has this characteristic of becoming a self-fulfilling prophecy. Finance will only build something if they think it will be profitable, if they think it will make money. But of course, the only things that can make money are the things that are in fact built. We don't get to see the sort of unbuilt solar project that they didn't decide to build compete against the fossil plant that they did decide to build. So to illustrate just a little bit more clearly about what I'm trying to say, a few years BlackRock responded to anti-ESG pushback by rolling out investor choice options. So these images all on this slide are all taken from BlackRock's marketing materials a few years ago. And they basically say, hey, clients, the transition is happening. No way to avoid that. Emissions are certain to decrease over the course of the next several decades. The crucial question is how fast will they decline? And so they show this sort of very simplified emissions trajectory curve showing different colored lines about how emissions might play out through 2050. Of course, you have the green net zero line in which we rapidly reduce emissions to net zero. And then we have other ways the future could play out, including the orange line in which we're not particularly ambitious, and the yellow line in which we start to carry out, and which all the different countries and institutions that have made pledges actually do carry out those pledges. So BlackRock says, we're going to give you a choice, investors, about how you would like us to manage your investments. You can either navigate the transition or you can drive the transition. And if you're navigating the transition, we're just going to invest your assets along what we think is the most likely thing that is going to happen. We're going to pick which line on this curve we think is the most likely. So say we think it's going to be yellow. We think that's the way the future will probably unfold. We're going to invest your money along a curve of which we think is probably going to happen. However, if you want to drive the transition, if you want to work towards pressing this yellow line closer towards the green line, then you can drive it. And then we're going to invest your assets along a different trajectory, and we're going to try to invest even more in sort of green activities and less in dirtier activities to try to push the most likely curve towards net zero, towards green. And so one thing I just want to point out that I think, and I'll say a little bit more about this, I think one thing that climate activists have realized is that the more you convince the players in the economy that the transition is happening, the more it will happen. The more you start to get institutional investors to care about potential stranded assets, the less that they will invest in capital expenditure, and the less emissions you will in fact have down the road. Okay, so we presented this question about whether you should invest along the yellow line or the green line, whether you should navigate the transition or drive the transition as a client of BlackRock. We presented this question as if an investor is taking emissions exogenously, as if they have nothing to do with emissions demand, as if they have nothing to do with the way the future transition will unfold. The market will set an emissions path and you just have to react to it. But the reality of these mega institutional investors is that I'm not sure it really makes sense to treat demand as like completely exogenous to their portfolio decisions. It's not just everyone else's net zero goal that you are evaluating. It's the goals that you yourself imposed upon your portfolio companies. So this is not in the complaint, and so far I haven't seen this part of this aspect of the case discussed. But one of the 3 public coal companies allegedly manipulated by BlackRock to reduce output was this company, Arch Resources. This is one of the coal companies discussed in the complaint. And this article from 2021 talks about how Arch Resources is considering shutting down certain mines in response to planned coal plant closure. They're saying Arch Resources is considering shutting down this Black Thunder mine because a bunch of the companies downstream of this mine that buy this mine's coal are planning on shutting down its coal plants. They've adopted net zero targets. And in particular, this article calls out DTE Electric, Amerin Corp, and École Energy. And as pressure builds to meet these targets, some companies could move coal plant retirements forward. And these 3 companies, DTE, Amerin, and École Energy, these corporate purchasers of Southern Powder River Basin coal, they are publicly traded companies, and their 3 largest shareholders, 3 of their 4 largest shareholders for all of these companies, for all 3 of these companies, are BlackRock, Vanguard, and State Street. And together, BlackRock, Vanguard, and State Street own collectively around 15 to 20% of these downstream coal demand corporations. So coal demand is also affected by investor pressure. Of significance to this case, I think this is from 2017. A shareholder vote received 45% support, so that's actually quite a lot of support in the corporate governance context, asking for DTE Energy to set climate targets in line with the Paris Agreement. And just 1 week after the vote, the DTE Energy chairman and chief executive announced that they would, in fact, reduce emissions by 80%. These 3 downstream utilities have been subject to an array of shareholder action over the years. Shareholders have requested linking executive pay to climate targets, reports on the business strategy in a 1.5C world, and the adoption of greenhouse gas targets. And shareholders have received commitments for each of these goals from at least one of the downstream companies. Okay. So, and of course, I just want to say coal plant closure in these cases is not entirely driven by investor goodwill or shareholder pressure. There was a lot of regulation and litigation surrounding the retirement dates of these coal plants. But I don't think that investor pressure was insignificant in the background of these decisions. But it's clear to me that even without thinking about investor influence about supply and demand simultaneously, that decisions focused on mitigating risk at the firm can influence market-wide output decisions. So the reason why climate activists care about things like climate disclosure or asking Exxon to complete audits of their business plan in a decarbonizing world is that they think these actions, even though they are focused on one firm, will in fact reduce emissions. And I think that they are right. Just to further explain, say investors were not concerned about stranded assets. They weren't asking companies to complete audits of how their business would fare in a decarbonizing world. They might finance projects that will get built, but then have to sell at below profit. They will have to sell at below the price that they would need in order to recoup their profits. They basically are going to have to sell at a depressed price. There's not enough demand for their product, but they're going to keep selling anyway in order to recoup some of their spent costs. So the effect of this is essentially an investor's subsidization of future oil prices and emissions. So is this conscious parallelism or tacit collusion? If BlackRock, Vanguard, State Street, CalPERS, New York State Pension Fund, if all the world's large institutional investors get together and sort of decide that the world is in fact decarbonizing, they think the Paris Agreement targets will be met, and they start investing their companies in line with the Paris Agreement, without necessarily agree with one another to do that, is this conscious parallelism or tacit collusion, and should it be illegal? And I'm highlighting this because I think this is potentially a lingering concern, meaning I don't particularly think that the Texas case against BlackRock is winnable under the Sherman Acts and the Clayton Acts. But there is room within the FTC enforcement authority for a whole bunch of different actions. And so I'm just highlighting here, even under Biden's FTC, of course, this course under Lena Khan, who was a progressive, who was advancing sort of a more fulsome enforcement of the antitrust statutes, and was encouraging the use of anti-competitive law to bar broader sets of competition that had been barred in the future. Biden's FTC argued that they would expand the scope of prohibited conduct to include practices that facilitate tacit collusion and parallel exclusionary conduct that may cause aggregate harm. And they might also prohibit conduct that uses market power in one market to gain a competitive advantage in an adjacent market by, for example, utilizing technological incompatibilities to negatively impact competition in adjacent markets. So note, under this interpretation that was advanced under Biden's FTC, there's no agreement between the parties required. Each party can sort of tacitly collude with one another using tools like industry associations or shared scenarios. They don't need to necessarily assign on the bottom line. There could be mechanisms that facilitate tacit coordination. And many other jurisdictions have recognized the potential for this problem, that there might be a fundamental contradiction between the goals of some of the antitrust laws and the competition laws and some of the policies encouraging collaboration, especially through supply chain agreements. So many other jurisdictions have created guidelines or legal safe harbors for industry collaboration on climate initiatives. This includes the EU, UK, Japan, Singapore, South Korea, Australia, and New Zealand. And this will just be my concluding argument before I take any questions or comments that you guys might have. I would argue that US antitrust law can be interpreted and enforced with climate change goals in mind, with climate nuance in the right hands, with the right politics, perhaps. And importantly, it's very important to keep in mind, of course, all green activity should not automatically receive an antitrust pass. The ultimate effect on welfare and competition should determine whether the activity is permitted. And luckily, actually, under the antitrust laws we have today, the doctrine that exists today, there's a thing called the rule of reason, which in many circumstances allows the judge to sort of weigh the different pros and cons, the cost-benefit analysis of the contested activity itself to see whether on a whole competition is encouraged or increased, and can also consider arguably broader welfare effects. And I would just point, this is a report from a couple of years ago for the American Economic Liberties Project, and they pointed out how private equity had really taken advantage of a lot of the subsidies given from the Inflation Reduction Act for the heat pump industry. And they argue that the subsidies from the IRA may have induced some bad, they argue, merger and acquisition activity that we see in the heat pump market. So they argue that private equity has really rolled up a lot of the heat pump market. They've really aggressively consolidated a lot of the heat pump market, which in the end might actually be bad for emissions if it results in anti-competitive price increases and it makes it harder for households to acquire a heat pump to decarbonize. So there's good competition, there's good collaboration, and there's, of course, also bad collaboration from the perspective of climate change. And I will stop there and would be very happy to talk about any of the stuff I talked about or any of the other challenges to universal ownership.
Thank you so much, Madison. We've got a sort of rich up to the moment playing field on this topic that, as you say, started out, I think, in quite a different place than it is today. We do have a few minutes for questions, and as I mentioned before, if you're watching live, please offer your questions and comments in the chat box on the right-hand side of the YouTube page. I'll get started with a question for you, Madison, which, as you think about where this is headed, it feels kind of dark at the moment in terms of, you know, illegal or not, or problematic or not. Many of the big institutional investors in the U.S. Have definitely retreated from these coalitions and the like. And I guess my question is, from your vantage point, are you looking at the those downstream companies that are consumers of these fossil fuels and sort of part of that market, and the way they're moving? Because certainly the pressures that you described on the coal industry haven't necessarily abated. You know, certainly it would not be economically rational today for a utility to invest in a huge coal-fired generation project. So it hasn't seemed to change, and those pressures still seem there, and there is a really strong economic imperative around renewable energy as it gets cheaper and all those sorts of things. So how do you see this playing out on the below the big institutional investor level as companies sort of work together and think about climate pledges, maybe a lot less publicly than a few years ago?
Yeah. You know, I think there's a lot riding on the demand side and a lot riding on what happens with data centers and AI, actually, if you're talking about in particular what happens with utilities and coal plants and coal demand in the United States. And I guess I would just link this to, you know, there's sort of an equal and opposite coalition building, or like opposite political future vision building happening in among the fossil groups, meaning like there is this sort of more insidious coalition, supply chain coalition I can see forming between AI, crypto, and fossil. Like they're all going to the same industry summits. The Saudis are inviting them to the same industry summits. BlackRock is at those meetings. Some of the institutional investors are at those meetings. And I guess I just would this is where the like self-fulfilling prophecy of finance is a really thing I've been like stuck on a lot, where it's competing narratives. Like fossil fuel really wants everyone to believe that AI is going to dominate in the future, because that way we'll build a bunch of data centers, and this building of the data centers will justify their reports to investors that like, oh, actually demand will plateau because we're just going to keep, or like our production demands will plateau because we're going to just keep adding so much more and more and more to the grid. And like, there's nothing inevitable about that. I guess I'm trying to say like there is a plan, there's no like free market inevitability of AI taking over. That is like the group of like a not particularly large, that's the decision of like of not that many people. Like a group of like 60 CEOs, mostly men, have decided that AI is going to be the future in a way that I think it manifests a version of planning, which is like at odds with how we think the free market happens. And right now, this version of like what the future will look like a data center heavy, rapacious AI demand. I think that this narrative of the future has taken like dominance recently, but I do think that this narrative can swing back. And that will be part of like a political shift that will also influence the financial analyses.
So as we think about the topics that you've studied and sort of the you know, at the intersection of areas that are often not in conversation with each other, corporate law, antitrust law, environmental regulation, I'm struck by how we seem to not have lost progress in the EU and the UK over some of these same concerns. And obviously there hasn't been a concerted anti-ESG political backlash, although there's certainly been flavors of it in Europe. But how do you think about US corporate and an antitrust law? And it's, you know, the legal debate that you referenced, how it's played out. And whether that suggests that we really need legislative or regulatory efforts, around this question of what investors are doing in the universal ownership context? Or is there, it just feels like there might be a bad fit between the sort of early 20th century conceptions that you've referenced, these acts that were really even earlier than that, bringing those concepts to bear on this very, very different concept with a very, very different market and different types of investors. Not that single investor picking stocks, reading all the annual reports in their, smoking jacket and with their pipe in the living room and trying to be the reasonable investor about where they should put their money. And the companies, sort of acting as, in a cartoon version of our economy. That seems to be the dominant sort of framework for how these laws were created. But as you allude to, this is way more complicated now, given the way the economy is structured.
It's so much more complicated. And and the laws are just incredibly inconsistent with one another, which I think has been my ongoing frustration. Like, and I think that some of the conundrums in the law, some of the contradictions in the law result in climate advocates be putting in this like sort of confusing position where they're like, wait, am I on the side of BlackRock? Like, is BlackRock a climate hero? Like, I don't really think it is, but Republicans sort of think it is. And I think in part it's because these institutions have resulted from, in part they exist to shield political pressure. Like, they exist to be middle managers that like absolve responsibility from their underlying clients. So sort of helps a lot of people being like, we can't do anything. Like, it's in the asset manager's hands. And then the asset managers get to say, we can't do anything. It's our clients' money. So I think that's part of what this ecosystem has resulted in. But there's a lot of laws that have made this happen. Like, one of the things that's very confusing to me about ongoing political fights right now is that the Republicans like allegedly hate BlackRock. Like, they allegedly think Larry Fink is a really bad guy. They think they have way too much power, that they own all of these companies. And yet, like, simultaneously, the Republicans seem like pretty interested in rolling back killing Social Security and turning Social Security into like managed 401ks, of which like the primary beneficiary would absolutely be BlackRock. And so like, I don't even really understand their like theory of political economy. And simultaneously, as they're thinking of doing this, they are removing the shareholder power that BlackRock does have. So they're removing all the ability that BlackRock has, which previous Securities and Exchange Commissions have required institutional investors to exercise their investor choice, saying it's your fiduciary duty to have an opinion on these corporations. The Trump administration is removing BlackRock, Vanguard, and State Street's ability to vote on these shareholder proposals or bring these shareholder proposals, simultaneously as they're proposing legislation that would funnel a bunch of money into them. So they're just creating this like headless zombie fund of money of like everyone's retirement savings that like no one's actually able to manage, because managing it would require considering climate change. So it's pretty maddening when you zoom out and try to like trace like where is this money actually coming from, and it's coming from like people's paychecks, people's like employment paychecks, and endowments. So it's ultimately public money. So I think it should be, I think once you see it as ultimately public money, I think you open up the possibility that antitrust law could be more normative, could be more accommodating of green investments, for example, and more punitive of non-green investments. And that would be sort of consistent with the goals of both like investor protection and antitrust law.
Let me build on that for a moment, because there has been this discussion. Certainly, activists have brought petitions urging large sort of institutions to divest from fossil fuels and to approach their portfolios from the perspective of climate risk, on the theory that, yeah, fiduciary duty to their beneficiaries actually mandates that level of attention and care to that reality, including not just the transition risks from a greening economy, but the real physical risks that we're facing as we see them in, in Vermont and in Texas, and lots of places just around the country, even at this level of warming, where significant economic damage can and does occur, and it will only get worse. And so those sort of petitioners are saying to their the places holding their money, or the organizations of which they're stakeholders, to say, you need to consider this. And in fact, state and maybe federal law in some instances actually mandates you think about this. So how do you, that seems like maybe another area of inconsistency on some level, but maybe it's not. What do you think?
Yeah, I mean, so definitely another part of this project, which I didn't present today because of time. Another part of this project is linked to the fiduciary duty, which is, I think, also linked to the questions of of the economic damages. So would it actually be cost benefit justified to make slightly missed money now in order to mitigate damages in the future? I've done a lot of work, at least in my assessment, I think, trying to show that it would be economically justified. And so the legal implications of that is, CalPERS, which is, by the way, the largest public pension fund for state employees in California, they have people retiring who, work for them now, retiring in 2060, 2065. When I read the science about what 2065 in California will look like, in the context of the global economy, it doesn't look very good. It looks, I think we will have economic loss. And of course, this is a contested opinion. You have to get a judge to believe that. And I think the sort of academic way of showing that is really evolving pretty rapidly, showing just how devastating 2065 will be. But if you believe that, if you believe that GDP will be less in 2065 than it is now, and that will affect CalPERS' portfolio, then there is a thing called the duty of impartiality that you could attempt to invoke, saying you have the same duty to people retiring tomorrow as you have to people retiring in 2065, and you are essentially sort of sacrificing the returns of people in the future for the returns of people today. And you could flip it around. You could make slightly less money today and sort of subsidize, local housing decarbonization, and everybody would be better off. And that claim has not been brought. I know there's been some discussion about what that claim would look like and who could bring it and who against. It's not a slam dunk claim by any means for a couple of reasons, but that's one way of framing fund duties for sure.
So last question for you, Madison. As you speak to students in your classes and others who are engaging with your work, as someone who has gone into come from an environmental background, challenging the rollbacks at the Institute for Policy Integrity, and have really jumped with both feet into this world of financial regulation, as well as markets and sort of the laws governing investment firms. We've asked ourselves here, what areas should students focus on going forward? And I think there was a lot of interest when the SEC was doing its rulemaking on let's all become, or let's definitely devote a substantial amount of our attention to securities regulation, disclosure requirements, and make that a huge area of growth. As you look at the landscape now, as you look at your students and where they're headed and topics that might be useful to them, what would your advice be to our students here, thinking through these questions about where should I focus? What if I'm concerned about these big societal problems, what do I do? Where should I go into this area that you've spent so much time in?
Yeah, I mean, I really would encourage students to take the sort of big, scary black letter business law courses, at least a couple. There's a lot of low-hanging fruit. Like, those two student populations are often very, very different. The people who specialize in understanding nature and climate science and environmental law are not the same people taking SecReg. And so that leaves like a lot of fruitful room if you, and I've advised students who have taken this career path, and my work has been in demand basically because I was able to sit in this space. And I think that, and that's there's only one way this is going to go, and that even if anti-ESG gains momentum and even if climate change remains so political, natural disasters are not going to stop happening. And so there's a bunch of room of work to be done in bankruptcy law, in financial regulation, in insurance law. Like, there are not enough people who know about the intersection of insurance law and climate change. Like, they're just like, it's shocking to me, actually. And so I would encourage students to, and the one other thing I'll say is, I wish I had taken some of those in law school. Like, some of those are sort of hard to learn in your own, like antitrust, hard. It's hard, actually. So I wish I had taken it in school, and sort of been spoon-fed it to me rather than trying to learn it afterwards. So that's what I would say.
Well, I think that's really great. I think that's really great advice. I think we sometimes do ourselves a disservice by focusing on areas, that, without by sort of not studying things that will absolutely have relevance going forward, even if the context in which we're pursuing them isn't exactly the context that everyone else is studying them for. Even if you want to be a nonprofit advocate, understanding all of the world of financial regulation and the way that investments work will only benefit your advocacy. So we're out of time, so we'll wrap up today's talk. And thanks again, Madison, for a really fascinating presentation. And thanks to all of you who are online joining us today. Our next talk will take place the same time this Thursday. Have a good day, everyone.